All right, let's jump in without further ado. I've lumped in patents and trade secrets together, but it's two different ways of protecting an idea you may have. A patent generally refers to as a government license, where if you have an invention, you can obtain this license, which will give you exclusive rights to your idea for a limited term. Trade secrets, and by the way, patents, you'll see in module 4, you'll see I've included Google's very first patent. You'll see the inventor is listed as Lawrence Page, Larry Page, one of the co-founders of Google. You'll see that that patent was originally assigned or transferred to Stanford University. Larry Page famously was a computer science grad student at the time that he had the idea for Google search. And then what ended up happening with Larry Page and his co-founder Sergey Brin is when they graduated from Stanford, they decided to go into business for themselves, right, and create Google. And what's really interesting, and this is why I've lumped patents and trade secrets together, is that today, for example, all of the innovations that Page and Brin and their, amazing team of computer scientists, all of the improvements they've done to Google search over the years, really today, instead of patenting those modifications and improvements to Google search, really today, Google, by and large, they protect their ideas via trade secret law as trade secrets. And it's really interesting that patents and trade secrets are very similar in that they're different ways of protecting an idea. But it's two different methods of actually asserting your legal rights to an idea. With patents, you have to do a whole formal application process with the United States Patent and Trademark Office. And you're going to have to show, and that's why I've shown you the Google patent. It's a very technical area of law, but what it boils down to is that what you're patenting can be patented. It's a useful invention, not a general scientific theory, but a useful, specific, concrete invention. And that it's useful, novel, and non-obvious. And so you have to prove those elements, establish those elements with the United States Patent and Trademark Office in order to get your patent application approved. Trade secret law, on the other hand, and trade secrets generally, couldn't be any more different. It's completely informal. With trade secret law, all you need to do is come up with a good and valuable idea. Whether it's novel, whether it's useful, whether it's non-obvious, it doesn't really matter. It just has to be a good idea. The most famous example of a trade secret is, of course, the Coca-Cola formula. But it's not really the best example. You can think of any product. I love, for example, Tabasco from Avery Island, Louisiana, the famous Tabasco product. I love spicy food. Tabasco, think about it, that recipe is a family trade secret, right? And the Tabasco owners of the Tabasco company, right, really built up a very successful business enterprise. Famous Amos cookies, chocolate chip cookies, and Sally's cookies, right? Recipes can be a trade secret. But really the best idea of a trade secret today, trade secret protection, is Google. Although Larry Page, when he was a student, he decided to patent his idea for a search engine. But today, as I was saying early, all of the modifications, innovations, and new things that Google is doing is basically now protected by trade secret. And with trade secrets, unlike patents, there's no formal registration. Trade secrets, it's purely common law. Purely common law. Now, there is something called the Uniform Trade Secrets Act. I've included a copy of this Uniform Trade Secret Act, or UTSA, in your module if you want to take a look, sort of summarizing the common law. But this basically varies state by state. But generally speaking, there's two requirements in order to protect a trade secret. in order to, have lawful ownership over your own idea. First, you have to have an idea that's commercially valuable, an idea that somebody would be willing to pay money for or provide something else of value. And secondly, and I would argue more importantly, you have to take steps to keep your idea a secret. You have to guard the secrecy of your idea. If you're going to go with trade secret protection under common law or state law. Patents, notice that's a federal area of law. I've included in Module 4, right, that clause within Article 1, Section 8, giving the power to Congress to protect and promote, right, the progress of the of the sciences and useful arts. One way Congress has done this is by creating a patent law and a federal patent registration system. But with patents, like you see with the Google patent I've included, you actually have to formally disclose that patent to the USPTO and to the world in exchange for getting, if it's a utility patent or a traditional type of new invention, in exchange for the 20-year protection. Okay, in my next video, I want to talk a little bit about infringement. And I actually want to do a detour from Tiger King and talk about Facebook. Because it is alleged that Facebook, that Mark Zuckerberg, basically stole the idea for the Facebook. He in essence engaged in misappropriation of trade secrets. So I do want to take a detour since Tiger King doesn't really involve trade secrets. And I do want to say a few words about the founding of Facebook. And then we'll move on to trademarks and copyrights and wrap up the module. Thank you for your attention.